Yeah, I respectfully submit that we've learned to understand more about sexual orientation and what it means to individuals. I guess the language that Justice Ginsburg used at the closing of the VMI case is an important thing. It resonates with me. A prime part of the history of our Constitution is the story of the extension of constitutional rights to people once ignored or excluded.
Thank you, counsel. General Verrilli. Mr. Chief Justice, and may it please the Court, Proposition 8 denies gay and lesbian persons the equal protection of the laws. You don't think you're going to get away with not starting with the jurisdiction? As an amicus, I thought I might, actually, Your Honor. And of course, we didn't take a position on standing. We didn't brief it. We don't have a formal position on standing. But I will offer this observation based on the discussion today and the briefing. We do think that while it's certainly not free of doubt, that the better argument is that there is not Article 3 standing here because, I don't want to go beyond just summarizing our position, but because we don't have a formal position. But we do think that with respect to standing, that at this point with the initiative process over, that petitioners really have what is more in the nature of a generalized grievance, and because they're not an agent of the state of California, don't have any other official tie to the state that would result in any official control of their litigation, that the better conclusion that there is not Article 3 standing here.
Well, tomorrow you're going to be making a standing argument that some parties think is rather tenuous, but today you're very strong for Article 3 standing.
Well, we said this was a close question, and our interests are, Justice Alito, in tomorrow's issues where we have briefed the matter thoroughly, and we'll be prepared to discuss it with the Court tomorrow. With respect to the merits, two fundamental points lead to the conclusion that there's an equal protection violation here. First, every warning flag that warrants exacting scrutiny is present in this case, and petitioner's defense of Proposition 8 requires the Court to ignore those warning flags and instead apply highly deferential Lee optical rational basis review as though Proposition 8 were on a par with the law treating opticians less favorably than optometrists, when it really is the polar opposite of such a law.
General Verrilli, I could understand your argument if you were talking about the entire United States, but your brief says it's only 8 or 9 states, the states that permit civil unions, and that brings up a question that was asked before. So a state that has made considerable progress has to go all the way, but at least the government's position is if the state has done absolutely nothing at all, then it can do as it will.
That gets to my second point, Your Honor, which is that I do think the problem here with the arguments that petitioners are advancing is that California's own laws do cut the legs out from under all of the justifications that petitioners have offered in defense of Proposition 8. And I understand Your Honor's point and the point that Justice Kennedy raised earlier, but I do think this Court's equal protection jurisprudence requires the Court to evaluate the interests that the state puts forward, not in a vacuum, but in the context of the actual substance of California law. And here, with respect to California law, gay and lesbian couples do have the legal rights and benefits of marriage, full equality in adoption, full access to assisted reproduction. And therefore, the argument about the state's interests that petitioners advance have to be tested against that reality, and they just don't measure up. None of
what is the one? Look, a state that does nothing for gay couples hurts them much more than a state that does something. And, of course, it's true that it does hurt their argument that they do quite a lot. But which are their good arguments, in your opinion? I mean, take a state that really does nothing whatsoever. They have no benefits, no nothing, okay? And moreover, if you're right, even in California, if they're right, or, if a PAC is enough, they won't get federal benefits, those that are tied to marriage, because they're not married. So a state that does nothing hurts them much more And yet your brief seemed to say it's more likely to be justified under the Constitution. I'd like to know with some specificity how that could be.
Well, because you have to measure under the standard of equal protection scrutiny that we think this court's cases require.
I know the principle, but I'm saying which are their good arguments, in your opinion, that would be good enough to overcome the state that does nothing, but not good enough to overcome California, where they do a lot?
Well, what we're saying about that is that we're not prepared to close the door to an argument in another state where the state's interests haven't cut the legs out from under the arguments. And I suppose the caution rationale that Mr. Cooper identified with respect to the effects on children, if it came up in a different case with a different record, after all here, this case was litigated by petitioners on the theory that rational basis applied and they didn't need to show anything. And so they didn't try to show anything. Our view is that heightened scrutiny should apply, and so I don't want to kid about this. We understand that would be a very heavy burden for a state to meet. All we're suggesting is that in a situation in which the state interests aren't cut out from under it as they are here, that issue ought to remain open for a future case. And I think the caution rationale would be the one place where you might leave it open, but you can't leave it open in this case.
There is an irony in that, which is the states that do more have less rights.
Well, I understand that, Your Honor, but I do think that you have to think about the claim of right on the other side of the equation here. And in this situation, the argument here that gay and lesbian couples can be denied access to marriage on the ground of an interest in responsible procreation and child rearing just can't stand up, given that the parents have full equality. The gay and lesbian parents have full equality apart from.
You want us to assess the effects of same-sex marriage, the potential effects of same-sex marriage, the effects of Proposition 8. But what is your response to the argument, which has already been mentioned, about the need to be cautious in light of the newness of the concept of same-sex marriage? The one thing that the parties in this case seem to agree on is that marriage is very important. It's thought to be a fundamental building block of society, and its preservation essential for the preservation of society. And traditional marriage has been around for thousands of years. Same-sex marriage is very new. I think it was first adopted in the Netherlands in 2000. So there isn't a lot of data about its effect, and it may turn out to be a good thing. It may turn out not to be a good thing, as the supporters of Proposition 8 apparently believe. But you want us to step in and render a decision based on an assessment of the effects of this institution, which is newer than cell phones or the internet? I mean, we do not have the ability to see the future. On a question like that, of such fundamental importance, why should it not be left for the people, either acting through initiatives and referendums or through their elected public officials?
I have 4 points I'd like to make in response to that, Justice Alito. I think they're all important. First, California did not, through Proposition 8, do what my friend Mr. Cooper said and push a pause button. They pushed a delete button. This is a permanent ban. It's in the Constitution. It's supposed to take this issue out from the legislative process. So that's the first point. Second,
well, just in response to that, of course, the Constitution could be amended. And I think I read that the California Constitution has been amended 500 times. So it's not exactly like the U.S. Constitution.
Of course not. But the aim of this is to take it out of the normal legislative process. Second point is that with respect to the concerns that Your Honor has raised, California has been anything but cautious. It has given equal parenting rights, equal adoption rights. Those rights are on the books in California now, and so the interest that California is that petitioners are articulating with respect to Proposition 8 has to be measured in that light.
Yeah, but the rest of the country has been cautious.
And that's why
and you're asking us to impose this on the whole country, not just California.
No, respectfully, Justice Scalia, we are not. Our position is narrower than that. Our position, the position we have taken is about states. It applies to states that have, like California and perhaps other states that have granted these rights short of marriage.
I want you to get back to Justice Alito's other points, but is it the position of the United States that same-sex marriage is not required throughout the country?
We're not. We are not taking the position that it is required throughout the country. We think that ought to be left open for future adjudication in other states that don't have the situation California has.
So your position is only if a state allows civil unions does it become unconstitutional to forbid same-sex marriage, right?
I see my...
Oh, you can go on.
Good, thank you. Our position is, I would just take out a red pen and take the word only out of that sentence. When that is true, then the Equal Protection Clause forbids the exclusion of same-sex marriage, and it's an open question otherwise. And if I could just get to the third reason, which I do think is quite significant, the argument here is about caution. It's an argument that, well, we need to wait. We understand that. We take it seriously. But waiting is not a neutral act. Waiting imposes real costs in the here and now. It denies to the parents who want to marry the ability to marry, and it denies to the children, ironically, the very thing that petitioners focus on is at the heart of the marriage relationship.
But you're willing to wait in the rest of the country. You say it's got to happen right now in California, but you don't even have a position about whether it's required in the rest of the country.
With respect to a state that allows gay couples to have children and to have families and then denies the stabilized...
So it's got to happen right away in those states where same-sex couples have every legal right that married couples do.
Well, we think
but you can wait in states where they have fewer legal rights.
What I've said is an open question with respect to those states, and the court should wait and see what kind of a record a state could make. But in California, you can't make the record to justify the exclusion. And the fourth point I would make on this, recognizing that these situations are not...
How would the records be different elsewhere?
Well, they might try to make a different record about the effects on children, but there isn't a record to that effect here. And the fourth point I would make, and I do think this is significant, is that the principal argument in 1967 with respect to Loving and that the Commonwealth of Virginia advanced was, well, the social science is still uncertain about how biracial children will fare in this world, and so you ought to apply rational basis scrutiny and wait. And I think the court recognized that there's a cost to waiting, and that has got to be part of the equal protection calculus. And so I do think that's quite fundamental.
Could I ask you a problem about that? It seems to me that your position that you're support is somewhat internally inconsistent. We see the argument made that there's no problem with extending marriage to same-sex couples because children raised by same-sex couples are doing just fine, and there's no evidence that they're being harmed. And the other argument is Proposition 8 harms children by not allowing same-sex couples to marriage. Well, which is it?
Well, I think what Proposition 8 does is deny the long-term stabilizing effect that marriage brings. That's the argument for marriage.
But you also tell me there's been no harm shown to children of same-sex couples.
California, there are 37,000 children in same-sex families in California now. Their parents cannot marry, and that has effects on them in the here and now. The stabilizing effect is not there. When they go to school, they have to, they don't have parents like everybody else's parents. That's a real effect, a real cost.
Well, a real cost right now would be you're asking me to write these words. A state that has a pact has to say marriage. Right? But I'm not telling you about states that don't. Well, I would guess there's a real world effect there too. But states that are considering pacts will all say we won't do it. Or not all, but some would. And that would have a real effect right now. And at the moment, I'm thinking it's much more harmful to the gay couple, the latter, than the former. But you won't give me advice as the government how to deal with that.
Well, we think that, as I started my argument, Your Honor, that all the warning flags for exacting protection scrutiny are present here. This is a group that has suffered a history of terrible discrimination. The petitioners don't deny. Petitioners said at the podium today that there is no justification for that discrimination in any realm other than the one posed in this case. And And so when those two factors are present, those are paradigm considerations for the application of heightened scrutiny. And so I don't want to suggest that in states that haven't taken this step, that they're going to have an easy time meeting heightened scrutiny, which I think has to
suppose one of those states repeals civil union laws.
It would be a different case. And all I'm saying is that the door ought to remain open to that case, not that it would be easy for the state to prevail in that case.
Thank you, General.